Hello, Kritika. Good afternoon.
Good afternoon, sir.
Okay. So, kindly introduce yourself.
Sir, I am Kritika Mishra. I am from Raipur, Chhattisgarh, born and brought up in Chhattisgarh. I completed my graduation from Hidayatullah National Law University. Thereafter, I completed my LLM from Renaissance University, Indore. And after my graduation, since then, I have been preparing for judicial services examinations. This is my second attempt at the MP Judicial Services interview. And here I am, sir.
Okay. So, Kritika, as you told, you are from Raipur, Chhattisgarh.
Yes,
Are you
sir.
not planning to crack Chhattisgarh Judicial Services?
Sir, in the past, I have appeared for Chhattisgarh Judicial Services as well. Once I have appeared there, but I couldn't crack the mains examination. In future, sir, I would certainly, if given an opportunity, I'll keep trying for Chhattisgarh Judiciary as well.
Okay.
But sir, irrespective of state, my prime targets are MP and Chhattisgarh. So whatever opportunity comes in hand, I'll be appearing for the exam.
Okay. So, even if you become a judge in MP Judicial Services, you will still be trying for Chhattisgarh Judicial Services.
Not exactly, sir. That is not the case. I have been trying for MP and CG since I have started preparing. And if I once get into the judicial services, that is more important for me, irrespective of whether it is Chhattisgarh or Madhya Pradesh.
Okay. Okay. And Kritika, you have said that you have done your LLM from the Renaissance University, Indore.
Yes.
Uh,
Yes,
so,
sir.
what was your specialization?
Constitutional law, sir.
Constitutional law. And what was the topic of your dissertation?
Uniform Civil Code. So it
Uniforms.
was regarding judicial. Yes, sir.
Okay, okay, okay. So, what exactly was it about?
A judicial approach towards uniform civil code, towards enforcement of uniform civil code.
Okay, judicial approach towards the Uniform Civil Code. Any specific state in India wherein you get to see the Uniform Civil Code?
Sir, Goa has uniform civil code, and recently Uttarakhand also became the first state to implement uniform civil code. Also, various other states have started contemplating towards forming legislations or towards like applying uniform civil code in their states. So as of now, sir, Goa is one state that I know has adopted uniform civil code. Apart from that, Uttarakhand, the recent one.
What is your stand as an advocate, as a person of law? What is your stand on the Uniform Civil Code? Should it be there or should it not be there?
Sir, since it is one of the directive principles that states should strive towards implementing judicial uniform civil code, what I feel, sir, it is important to make each and every legislation I think each and every legislation should focus towards making gender neutral laws and everything instead of just imposing one code for everyone, because as we see, India is a very diverse nation, so implementation of uniform civil code, one legislation for each religion, is not a very achievable task. So I think instead of implementing just one law for each and every religion, every legislation has to be properly amended and properly looked at. Whatever lacuna are there uh, regarding laws favoring or discriminating women, those laws needs to be improved more, uh, rather than just making one law, because sir, it will be very difficult to accommodate as the diversity is as far as the diversity of India is concerned. It will be very difficult to accommodate the views of each and every section, each and every religion, and to make them consent to make them concede to form just to follow just one uniform code. So I think instead of implementing one code, there can be changes in the existing laws, so that all the laws serve the purpose of removing the discrimination against women or children. That is what I believe, sir.
Okay. Uh, Coming back to the main point of your interview because this was just about your LLM and the specialization. What exactly is your area of interest? When we look at the subjects, there are 12 subjects in MP civil judge examination. Is there any special area of interest that you hold?
So since I opted for criminal law honors during my graduation, so since then I have a keen interest towards criminal subjects, CRPC, IPC, and Evidence Act. But it's not that I don't like the other subjects. So I am good with any of the, but evidence law specifically interests me a lot.
Okay. Fair enough. So if we talk about the criminal law, can we talk about CRPC or should we stick only to the Indian Evidence Act?
Sir, we can talk about CRPC as well.
We can talk
I'm
about
fine with it.
CRPC. Okay.
Yes,
Okay.
sir.
So what exactly are the types of remand that are provided under CRPC?
Sir, there are basically three kinds of remand: the police remand, judicial remand, and the other form is also known as transit remand. So, as per section 167 of CRPC, uh, police remand police remand is provided under section 167 of CRPC. So when the custody of the accused is given to the police for carrying out certain investigations, then it is called as police remand. The maximum period for which police remand can be granted should not be more than 15 days. Apart from that, there is another kind of remand, which is judicial remand. So there has been the provisions of 167 CRPC itself talk about judicial remand as well. Whenever an offense, like if the offense committed by an accused is 10 years or more, till the life imprisonment or death, or 10 years or more, then judicial remand can be given for a period of 90 days. Apart from that, if there is any other offense, then it can be extended to 60 days. Transit remand has not been expressly provided under 167, but transit remand essentially in common terms means that the time, it is the law that every accused who is arrested needs to be presented before the magistrate within 24 hours of arrest. So in case the transportation or in case the time period which is required to take the accused to the magistrate is longer than 24 hours or more than that, then this period is known as the transit remand or transit period. This transit period is also known as transit remand because at that point of time the custody of accused remains with the police only. So these are the kinds of remand that
are
I know
provided
of.
under CRPC. Okay.
Yes,
So,
sir.
Kritika, let's say a person is arrested and the person is presented to you after 3 days. You are a judicial magistrate and a person has been arrested. He is presented to you after 3 days. So, in that period of time, in those 3 days period of time, around 1.5 day, 2 days were just required to take or convey that person to your court. It was the time required for journey. Will this entire time period of 3 days be included or excluded from the time span of 15 days that you have provided for police remand?
Sir, the time period that is required to the time period of the travel, that will be excluded from the time of 15 days. The day when the accused is presented before the magistrate, from that day, the time period of 15 days is counted.
Okay. Let's say a person has been already sent to judicial custody by you. You have already given a judicial remand to a particular person. Can that person be again put to police remand? If need be, can that person be again put to police remand or not?
Sir, the period of 15 days needs to be taken care of. If it has been more than 15 days that the police remand has already been granted, of 15 days, then thereafter such person cannot be given back to the police, like he cannot be granted police remand.
Okay.
And if after 2 or 3 days I have granted the judicial remand to that, if I've given the judicial remand, and if a request has been made from the police that further investigation needs to be done on their part, then yes, he can be sent to police remand
Are
back.
you sure about that?
Yes, sir.
Okay. Okay. Fair enough. ठीक. So when we talk about arrest of a person, what are the other modes of compelling appearance of a person in the court? अगर आप एक मजिस्ट्रेट हैं और आप चाहती हैं कि किसी व्यक्ति को आपके सामने प्रस्तुत किया जाए, तो अरेस्ट के अलावा और क्या तरीके हैं उस व्यक्ति को आपके सामने प्रस्तुत किए जाने के?
सर फर्स्टली सर समन्स इशू करके उनको प्रस्तुत किया जा सकता है. अगर समन्स से काम नहीं हो पा रहा है तो देन वारंट कैन बी इशूड. आफ्टर दैट, अगर डिस्पाइट ऑफ इशूइंग अ वारंट दैट पर्सन कैन नॉट बी प्रोक्योर्ड बिफोर द कोर्ट, देन proclamation is another method by which that the attendance of that person can be ensured before the court. Proclamation is provided under section, as per the provisions of section 82 of CRPC. A proclamation can be issued for that person to be brought before the court.
Okay. And attachment can go contemporary to proclamation?
Yes, sir.
Okay.
The provision itself provides that there can be simultaneous attachment. Attachment can be done simultaneously with the proclamation.
Okay.
To appear, for the person to appear before the court.
Okay. 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 Let's say a person has been presented before the court and the charge sheet is also presented before the court. आपके सामने चार्जशीट भी आ गई है, आपके सामने पुलिस ऑफिसर भी आ गया है, आपके सामने अरेस्टेड पर्सन को भी ला दिया गया है, विक्टिम भी है वहीं पे. अब अगली प्रोसीडिंग क्या होती है? इसके बाद क्या होगा? What will be the next stage?
Sir, once the charge sheet is presented, the magistrate looks into the case, like prima facie. If the magistrate finds that certain charges as framed by the police are, if there is a reason believe, or there are reasonable, if there are reasonable grounds to believe that the accused has committed the offences as charged, then the court will proceed with the trial. Or if not, then there is also a provision when where the accused can be discharged. If it
Which
is a
provision-
warrant.
Which provision talks about the same?
Sir, if it is a warrant trial, as charge sheet is presented, so warrant trial instituted on police report. So 230, sir, I'm not able to recall the exact section, but after the charge sheet is presented, then there is also there also lies a discretion with the magistrate that if he finds that no offense is committed, if he finds that the offense has not been committed by the person, then there is a provision of discharge. 227 of CRPC.
Okay. It's a warrant trial you are talking about, and you are saying it is 227. Are you sure about this?
Yes, sir.
Okay. What is the difference between withdrawal and discharge? Yeah. What is the difference between acquittal and discharge?
Acquittal essentially means we are absolving that person from all the charges, and discharge means if there is need, that person can again be called before the court. So acquittal absolves the person from all the accusations and all the charges.
Okay. Okay. What effect does a compounding of offense do on a particular case. Compounding of offenses का effect क्या होता है? Discharge होता है, acquittal होता है?
Acquittal.
Are you sure? Where is it provided?
Section 320 of CRPC.
Okay. Can a case of extorting confession from a particular person done by a police officer, is this matter compoundable or non-compoundable?
Sir, I'm sorry, sir, I cannot recall as of now. There is a list provided under Section 320 of CRPC, but I am not sure as to whether it is compoundable or non-compoundable.
Not a problem. When we look at confessions, since Indian Evidence Act is one of your fortes, when we look at confession, what does section number 29 of the Indian Evidence Act talks about?
Sir, if a confession has been made by a person under any kind of influence or under any kind of not exactly influence, but under a promise of secrecy, or by giving any kind of lurement that he can evade the sentence, or if it is made and in a stage where that person is intoxicated, then also such confession is valid, despite the fact that, yes, sir.
Okay, so what is the difference between the allurement or promise which is provided under section 29 and inducement that is discussed under section 24?
Sir, when we talk about, sir, like for example, narco analysis test, when we talk about narco analysis test, in that situation, a certain chemical is injected to a person, and in that intoxicated state, a confession is made by that person. So just because that person has been intoxicated, it does not mean that whatever is coming will not be considered by the court. But if we are threatening a person to, or compelling a person to make certain confessions, uh, which does not voluntarily comes from that person, that will be covered under section 24 of Indian Evidence Act. So that will not be admissible. Confession necessarily has to be voluntarily made.
Okay.
But when we...
Okay. So section 24 has a person in authority, while section 29 does not have a person in authority. Maybe,
yes, sir, might not.
Maybe that is the difference between the two, standard difference. Okay. While we are looking at the Indian Evidence Act, what exactly is the significance of section 165 of Indian Evidence Act?
So section 165 of Indian Evidence Act gives enormous powers to the judge to put questions or order production of evidences before the court. If there is a situation where court feels like putting questions to any person, then the court has the power to do so. But there are also certain, if the court wants that a certain piece of evidence needs to be produced first, then also court can order the same. But at the same time, there are certain restrictions also provided under section 165 of Indian Evidence Act. If any evidences which form under the category of privileged evidence, or which are barred under section 121 to 131 of Indian Evidence Act, then such person cannot be questioned about any such privileged he cannot be compelled by the judge to disclose such information which is privileged. Secondly, if there is another restriction provided there, that if a particular document is not, if a secondary version, or if a secondary document cannot be produced, if the ingredients of section 65 of Indian Evidence Act, which allow the production of secondary evidences, are not fulfilled, then also a judge cannot make someone produce secondary evidence, or cannot allow secondary evidence to be taken into evidence. Apart from this, sir, the power of production of documents and to put questions during cross examination and examination of the witnesses and parties has been given to the magistrate or to the court under section 165 of Indian Evidence Act.
Okay. Okay. You mentioned a word secondary evidence. Is there a best evidence rule about the secondary and primary evidences?
Yes, sir.
What is it?
So section 91 of Indian Evidence Act provides that any contract, grant, or disposition that is made in documentary form needs to be produced or needs to be proved in the form of that document itself. No secondary evidence shall be admissible. A document always needs to be proved by presenting that document before the court only. But there are certain exceptions to this rule as well. Section 92 provides for the exceptions. There are 6 exceptions provided under section 92. Like if there is a separate oral agreement which does not invalidate the earlier document, which it does not invalidate the original agreement, or if there is any custom that needs to be proved apart from producing, that cannot be proved by in a documentary format, that needs to be orally stated before the court, then if any of the situations of all these 6 if any of all these 6 situations are there, then court may permit secondary evidence, then court may allow secondary evidence as well, or oral evidence as well, as oral evidence also forms a kind of secondary evidence which is also provided under Indian Evidence Act. So
okay. Oral evidences must be direct. This is provided under section 60. What are the conditions
yes,
when the oral evidence may not be direct, but yet it can be relevant?
sir, if there are if an the evidence given by the evidence of an expert can be proved by the treatises, sir, I'm not able to explain
Shall I
it
reframe the
properly.
question
And
for you? Shall I reframe
sure,
the
sir.
question for you? What are the
Yes.
exceptions of hearsay evidence?
Okay. So there are exceptions. Dying declaration is one of the exceptions of hearsay evidence. Also, admissions and confessions are exceptions to hearsay evidence. In these situations, even though the evidence is hearsay, then it forms a strong kind of an evidence and it is admissible before the court.
So you said Indian Evidence Act is your forte, it is your strength. Okay. Fair enough. What exactly is the relevance of an injured witness? Let's say there's a witness who is an injured witness. What is the relevancy of his statement?
The statement of an injured witness is considered as a very strong piece of evidence, and it is highly regarded. Also, because it is believed that a person who is injured will not spare his actual assailant. And recently one of the Honorable High Court, I'm not sure whether it is the judgment of Honorable High Court or Supreme Court, but recently there has been a judgment that injured witness always needs to be examined by the prosecution. If a witness is injured and if injured witness is not examined, then it might make the case of the defense fatal. It might like if an injured witness is not examined, then it can be very it can be very helpful for the defense, and it can make the prosecution case fatal as well. So the examination of injured witness uh, is very important, and it is highly regarded.
Okay. Okay. While we are talking about evidences, Kritika, what are the evidences which, if presented before you as a magistrate, will help you decide a case relating to dishonor of a check? अगर आप एक मजिस्ट्रेट हैं, आपके सामने डिसऑनर ऑफ चेक का कोई मामला आता है, तो आप अपने सामने कौन से ऐसे तथ्यों को, कौन से ऐसे साक्ष्यों को चाहेंगे कि ये अगर मेरे सामने हो तो मैं एक सही जजमेंट दे पाऊं? कौन से एविडेंसेस होंगे?
So the bank's slip
Okay.
is prima facie considered as an evidence for establishing the. Apart from that, sir, so that's all. Bank slip is considered as a prima facie evidence of dishonor of a check.
अच्छा, तो खाली बैंक स्लिप के बेसिस पे आप डिसाइड कर देंगे मामला कि ये डिसऑनर ऑफ चेक हुआ है? यहाँ पे खाली बैंक स्लिप आ गई मतलब डिसऑनर ऑफ चेक हुआ है, नथिंग एल्स इज रिक्वायर्ड, एंड बस दैट इज इट? मतलब ये नहीं देखा जाएगा कि किसी व्यक्ति के खाते से पैसे चोरी हो गए हो, ये नहीं देखा जाएगा कि उस व्यक्ति को पता ही नहीं था कि उसके अकाउंट में पैसे हैं या नहीं है, ये सारी चीजें
Sir,
आप डिस्कार्ड कर देंगे?
no, sir. Prima facie bank slip will be one of the important evidences. Apart from that, sir, trial तो चलेगा ही और उसमें सारे examinations होंगे और भी documents. Exactly क्या produce किए जाएंगे that I don't know, sir. But
These will be, the bank slip will be
that
the,
will be that will provide a ground for me to go with the case,
okay,
go
so that
forward
will
with
be
the
a
case.
substantive piece of evidence for you to decide the matter either ways.
Yes, sir.
Okay, okay. Good job, Kritika. Good, 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 good. Great job.